Good morning. Chris Bacon here, Director of Marshall Street Tenant Association. It's Saturday, June 5th at 10:30 in the morning, just after 10:30. I want to say hello, how are you? I hope everybody's well in this time of COVID, staying safe. As a person with a disability, they've left me to write it down, go complain somewhere, including being rejected at 2 different clinics. First one, February 8th, Onyx Medical, February 8th. I was basically assaulted and then almost bribed because I was getting a DTC, and he claimed that he didn't have enough information. But as I'm leaving after being assaulted and saying I'm leaving, the girl stops me at the desk, says, "Hey, give me $120 so you can have your form." Anyway, you might want to take a look at that. And investigating the doctor through the CPSO that's there, Dr. Cam, Michael Cam, we find out that he is actually under supervision. You need to go to CPSO, look up Onyx Medical and Dr. Michael Cam, because you need to know that they're allowing people like this to have access to patients. And this is also part of the same thing, because all colleges, so physicians, surgeons, nurses, anything that is in the college level or tribunal is all controlled by municipal affairs and the Crown and Right of Canada. You go to make any complaint against anybody, you need to start with the Crown and Right of Canada, or it's not legitimate, and every lawyer knows that, and they are forbidden from putting that down. Matter of fact, you look at the human rights history of the Human Rights Tribunal and how they did this. This is why Canada is the way it is. This is designed and engineered to do what it is doing. Make no mistake. I'm a person with a disability who became disabled with a brain injury in 2004. From that moment forward, because of memory problems, I have recorded every contact at every point of contact with any government agency while they're rolling out these human rights and AOTA and everything else. This is a study as it's happening. So all their rhetoric and bullshit aside is right here, which is why I am the most dangerous person when I'm in danger, which is why they're trying to shut me down, because they cannot, not in a court of law, which is why they shut it down there. And now I'm imprisoned with the rest of you, as is Carrie and Austin. And this residential rental license thing was to protect the persons that are most vulnerable. Engineered by Shane Turner, which you need to understand. Shane Turner, this is amalgamation. Because Shane Turner they're just doing it that, you see, Mayor Jaworski is also regional councillor for Waterloo. And Shane Turner, in researching what happened, Shane Turner was with the city of Kitchener. And he did his magic there first. Then he was hired by the city of Waterloo to do the same thing here. So instead of actually electing people doing it right, they're doing it through the back door. And this is by design. So Shane Turner was brought in specifically in 2015 to deal with the residential rental license and business licensing in the city of Waterloo. It's the way they do business. Anyway, as a person with a disability, I'm forced to write this down. I'm doing the best I can given the circumstances. So, I have decided we have more than enough evidence, regardless of how they want to treat this, especially with what the Landlord-Tenant Board has been exposed, and Tribunals Ontario has just been exposed, that they did. Because there's only one way this happened. They had to have the full cooperation and participation of the municipal affairs and housing at all levels. So it took me until Friday, May 31st. I started it a week earlier, but I put the date as that date because there's an outstanding work order, and I calculated the number of days outstanding up until May 31st. So just to let you know, it's a little bit long of a letter because it's got attachments. But this first page here is all just the addresses, various addresses of who it has to go to. So I'm not going to read all the addresses. I'm just going to say who it was sent to. And it'll be posted up that you can see it for yourself. Because this is legal notice on behalf of all taxpayers, renters, and residents of Ontario and Canada. Because banking is federal, right? Anyway, so right at the top here it says, legal notice, pending cause of action. Also sent by email. Okay, so right there, legal notice, pending cause of action, which is official notice, and it's been sent by all channels. They are aware. So it's been sent to Doug Ford, Premier of Ontario. Of course, we sent it to Steve Clark, Minister of Municipal Affairs and Housing, and Ian Kerr, which is the Regional Director for Southwest Region of Municipal Affairs and Housing. So he is in charge of all things under. So he's Regional Director, so he's in charge of everything in this region. And he also is in charge, so for everything from here to London. Southwest Region. Go look at how big it is. As far as the region goes, we sent it to Bruce Lochner, Chief Administrative Officer, and Rod Rieger, Commissioner of Planning, Development and Legislative, and Karen Redmond, Regional Chair, at the Regional Municipality of Waterloo. That was sent by separately, that's one of the notices sent. Bruce Lochner, sent by registered mail, signature required. Any one of those. The City of Waterloo, we attention Tim Anderson, which is Chief Administrative Officer for the City of Waterloo, Mayor Jaworski, and Shane Turner, Director of Municipal Enforcement for the City of Waterloo. That was also sent by registered mail, signature required. It was also sent by email, and it was sent by fax. And it's also sent to Tony Brutal, Team Lead, London Office, Western Municipal Services, Ministry of Municipal Affairs and Housing. That's the one who I've been talking to, asking for, you know, we had to go to him for accessibility, and, well, go look at the tapes. You'll find out how your taxpayers are hardly at work for you. Hardly at work for you and me. Pays their salaries though. It's also provided as an answer to their SWL 46391-20, which is an unlawful order, because they made an unlawful order that says that we are to pay rent here ongoing until this is settled. Even though they haven't done it properly, they were at a loss for what to do, so they went, well, you can pay the rent for May, because they thought we weren't going to do it, but we did. We did in good faith. And we're going to get kicked out anyway, because, hey, they're not following the law. Do you think we're dumb? Anyway, it was as a test of faith, and to show that, again, here we are. Anyway, it's also sent out to Keisha Brooks at Human Rights Legal Support Center, because, again, it was my discussions with Keisha Brooks and the Legal Support Center in trying to deal with any of this, especially when it came to the medical situation. All of a sudden, it gets rushed. They did this underhanded ex-parte thing when they knew I wasn't down. Like I said, it's very telling. You need to pay attention. Anyway, so that's page one. I'm just going to stick to the script, the letter, because this is going to take a little bit. So all contacts is to be directed to the following address, which is myself. And again, there was a letter sent like this in October 30th to Mr. Bruto, where it says clearly the only contact is me at this address. And yet, they tried to make it look like, I don't know what they tried to make it look like, but it doesn't matter, because the bottom line is we were not served. It is their responsibility, and the landlord-tenant is required to send you the documents directly. So the fact that in more than one of these cases, multiple times these same people come across as 2 different, 3 different groups on this address for the same issues, dropping it, here we are. Sorry, I'm getting upset because this is upsetting. So it's sent by registered mail regarding City of Waterloo residential licensing permits issued 98B for 98B Marshall Street, Waterloo, Ontario, and 100A Marshall Street, Waterloo, Ontario, namely but not limited to, and here I put down The license is for 98B Marshall. 2020 license is residential licensing permit number 20200054445. It's Class A 4-bedroom for Unit B, issued March 26, 2020, with expiry date of August 31st, 2021 by Shane Turner, to the owner, 2576514 Ontario Inc., 455 Old Oak Drive, Waterloo, Ontario, Norman 2T, 2 Victor 8, and property management company Mark Koenig, operating as Chief Financial Officer, Atlas Property Group, Waterloo Inc., 1 King Street North, Floor 3, Waterloo, Ontario, Norman 2 Jack, 2W6. Info at atlasproperty.com. Mark Koenig also operates as Koenig Holdings Inc., property management for same properties, same ownership control, separate corporate entities. And the residential licensing permit number 2019-004347, Class A 4-bedroom, Unit B, issued October 3rd, 2019. Expiry date March 31st, 2019 by Shane Turner, to the owner, 2576514 Ontario Inc., 455 Old Oak Drive, Waterloo, Ontario. Then for 100A Marshall Street, the 2020 license today, that's licensing this property right now, is 20200054441, Class A 4-bedroom, Unit A, issued March 26, 2020, expiry date August 31st, 2021 by Shane Turner, to the guys. Then also residential, this is the one here that we went, that started this whole thing with the video series. It was residential licensing permit number 201900439, Class A 4-bedroom, Unit A, issued June 19th, 2019. Expiry March 31st by Shane Turner, to the owner, and this is important because they got it under a different number. 2011987 Ontario Inc., 455 Old Oak Drive, Waterloo, Ontario, Norman 2 Terrace, 2 Victor 8, and local contact Theo Papadopoulos, 519-569-1905, CWW Inc. at Outlook.com by Shane Turner, in violation of an outstanding provincial work order signed on June 13th. Completion date by July 15th, 2019. So they came and did when you go and look at the video series, they came out June 11th, or 9th and 11th, somewhere around there. Did several inspections, came out, finally did an order, and dated it for June 13th. They're only allowed to give 30 days to fix, but she made the completion date July 15th, which means technically she started the order on a Saturday, because the 13th of June was a Thursday, which makes 15th of June a Saturday. So she actually ended up giving them 32 days. But they didn't matter about that, because 6 days later, on the 19th, they filled out the rental license to cover his ass. But again, was it unlawful to collect rent? Again, who are they protecting? You need to go take a look, see for yourself. Because the other thing you need to understand is we did not videotape this based on our other experiences. That's why we did. We needed to document it this time, and it's all there in real time. We invite you to go see it. But just a quick note about these licenses. So we get the alarm about these aren't licensed. We start questioning about, what do you mean it's unlawful to pay rent? And is there a license? And they refuse to answer the question. Instead, they start working with the landlord to do this. They finally come up with a work order dated June 13th. It says director not allowed to issue license with outstanding work order. Period. So they just wrote the work order, and 6 days later they granted him a license before a hammer was even swung, and then even before a hammer was swung, decided that we consider the case closed when they're not allowed to. So it's very obvious what they did here. Well, to us, go look at the evidence. Go look at the real-time videos. And then ask yourself if this is the way it's supposed to be done. Everything with the exception of the last ones that I just posted, because I haven't had a chance to do them yet. I had to get the videos up first, so those descriptions haven't been filled out when it comes to malfeasance, misfeasance. I'm going to endeavor to do that because this has been more important. But, you need to go look at it. and see for yourself. So the work order, and that's attached, 5 pages, is still not completed, and as of May 31st, 2021, is 686 days overdue and counting. Provincial Work Order, June 13, 2019. This proves that it's still not completed, because on the Provincial Work Order, dated June 13th, 2019, item number 5 says railing, rear deck to parking lot, and number 19, chain link fence. Note, fence in number 19 is actually from 98B property, listed correctly as not to code and still outstanding 686 days later. Same owner under separate business number, same property management, Mark Koenig. Now, the addresses are the same, so again, a little due diligence, and hey, if we had standing, because again, anything we say has no standing. That's what it means for no standing. And that's how they're treating everybody. We handed them, we went to the public record, which is all in the public record. So why doesn't Shane Turner and them know about it? Right? They're required to. This has a history. The fact that they gave them the license over there right away. And because I pointed out after they did the order that you made a mistake and included the fence is not 98 or 100 A's fence, it's 98 B's. And that delayed them giving the license until October 3rd, 2019, to get the license here. Which means, so from March until October, were we licensed? Was it to code? Again, this is more than enough questions to say Shane Turner is using this department to direct whatever he wants under feigned judicial immunity. In spite of the law. But that's my opinion. Go look for yourself. It's very telling. Anyway. So, this is the meat and potatoes of it. So it's specifically about those 4 licenses with regard to these 2 properties based on that work order and the history that we have documented. In the matter of the City of Waterloo, Region of Waterloo, and Ministry of Municipal Affairs and Housing, alleged gross negligence in failing to exercise proper due diligence, abuse of process, examination and mismanagement of the public record, misuse of public funds and interference through multiple apparent misrepresentations of fact by the municipal enforcement officers and investigators, Manager Shamir Maida and Shane Turner, Director, and others, did abridge the Ontario Municipal Act, the City of Waterloo Residential License Bylaw 2011-047 and the Fencing Bylaw 2013-017 and the Division Fence Bylaw 09-009 through malfeasance, misfeasance, misrepresentation of malicious intent, and failure to prevent the collection of unlawful rent through the unlawful lack of enforcement, and through gross negligence, thereby allowing and facilitating the maintaining of an unlawful rental business contrary to the residential licensing bylaw, through an apparent active participation, assisting in ongoing misrepresentation and continuous fraudulent actions by Theo Papadopoulos, operating as Commissions Worldwide, Inc., owner, and Mark Koenig, operating as Atlas Property Group, Waterloo, Property Management, and Koenig Holdings Property Management, and Small Matters Paralegal, and others, for all ongoing harm, damages, and costs, including human rights abuse and egregious harm, including unlawful arrest, assaulted detention, unlawful eviction, harassment, assault, and possibly wrongful death in the matter of John Lichty. I ended the sentence ends at possibility of wrongful death. Malfeasance, misfeasance, utilizing through an apparent gross dereliction of duty under law, including obstruction of justice, gross negligence and unlawful conduct of the Ministry of Municipal Affairs, oversight of Police Act service providers and stakeholders, including human rights abuse within the system, improper conduct and misrepresentation by municipal enforcement officers and others, while practicing excessive use of force, for example, against the tenants, while exhibiting an apparent inappropriate use of force and direct interference in our tenancy contracts and using our disabilities against us, and denying even our basic legal rights and proper representation as apparent protection for the owner, landlord, and the system, with a definitive lack of enforcement by restricting us to a system of willing partners, including the police, tribunal system, and regional community legal system, to restrict scope of representation to paying for rent on buildings that barely meet minimum building code, which is the sole responsibility of the Minister of Municipal Affairs and Housing, no matter who he chooses to delegate his authority to. Whether deliberate or by error, this apparently allows them to misrepresent the facts, which continues to contribute to and aiding and abetting of this unlawfully acting ministry and its affiliates and subordinates and property owner and others in ongoing issues at 98B Marshall Street, Waterloo, Ontario, and the direct connection to improper hearing and unlawful decision with the LTB case file SWL 32448-19, an outstanding work order for 108 Marshall Street, Waterloo, Ontario, required to be fulfilled by July 15, 2019, of which the Marshall Street Tenant Association, MSTA, was a party to and is a part of this action. We believe these events prove unequivocally that the landlord, owner, and his agent knowingly filed and gave false information testimony under oath and perjured themselves in the matter of SW 3244819 and further in the applications for rental licenses for these properties, given the proof that these properties do not meet basic building code standards, and there is a real question of negligence on the part of the Municipal Enforcement Department operating on behalf of the Region of Waterloo and the City of Waterloo and Province of Ontario. And all these licenses were given unlawfully, as there is still an outstanding work order, and are misrepresented as lawful and in compliance with the bylaws and building code, including by the ministry themselves. They are reinforcing the $450 in the marketplace for somebody to go and get a housing inspection. Ministry of Housing Affairs is the one who determines whether or not you're allowed to do that, and you're not. As a renter, you cannot do that. You have to ask yourself why, because again, they are responsible for the bottom line, regardless. So if the landlord isn't doing their job, then the municipality must, which is what this order is all about. So go look at the modus operandi, because this is their business plan. This is what they mean when they say open for business. They have lawyers running interference. It's a legal issue, deliberately so, by design. A prison is defined as a system of containment run by the state. How many more questions do you need? This is just warming up too, because you have no idea. Under the Ontario Municipal Act, no person is allowed to give false statements or form of misrepresentation in an investigation. Certainly begins with the municipal enforcement officer tasked to determine the facts, not to undermine and cover them up, or to use municipal enforcement order as nothing more than a prop against disabled, law-abiding, responsible tenants. Municipal enforcement, fire inspectors, and police are also governed under the Police Services Act, which appears to be violated as a matter of course given the circumstances herein with regard to possible and exposed misrepresentation. For example, more than one property failed fire inspections right after obtaining a rental license. Go take a look. Both of these properties, especially 98B, because again, 98B has a history, which again, I would assume that's probably why they waited till October to give them the license in 2019. All of which is a matter of record. All of which we handed them at that hearing. All of which they went, well, that's in our way, so we just, notwithstanding, and carry on. We've had